to us about your interest as Amabhungane investigative reporters in this particular case. Are you with either side, whether it be the side of the president or the EFF, or you're taking a more middle ground?
Good morning, Toli. Yes, so Amabhungane is not taking sides in this particular dispute. We are on the side of openness and transparency in relation to court records. So as to the particular merits of this case, we do not have a view as to whether these records should be sealed or unsealed. Our argument that we are putting before the court today is that if the court is find themselves having to make a decision as to whether to bring down a veil of secrecy or open up records to the public, that openness should be and is the default position, except in certain extraordinary circumstances where there's a real danger that harm may arise from opening up those records, and that harm or danger outweighs the benefits of openness and open justice.
Yeah, I wonder, Cherese, if there is an opportunity for you to give us an example of what an exceptional case would be where you say it would be compelling enough for the courts to seal any information from the public.
Well, this case concerns political party donations, but if you think of the types of cases that find themselves before the court, there may be instances where unsealing information may lead to physical harm, for instance, put somebody in actual physical danger. That's something we would say would have to be balanced very carefully if somebody was going to ask that those records be unsealed. So that's the kind of harm, but at the moment we are talking from a hypothetical perspective. We would want the court to invite the parties to put forward what they think, what harm they think may arise, and weigh that against the competing consideration of open justice.
Yeah, Amabhungane, Cherese, are in a very interesting position, and I say that because there's a recent court judgment that came out to say that one of the journalists belonging to Amabhungane was spied on illegally by state agents, and I'm just wondering whether the president might not have the same legal argument, or are you saying that different rules should apply?
Absolutely, that situation is completely different to this one. We're not saying that privacy should never be put into the mix and considered when making the determination. But what happened to Sam Saul, our managing partner, was really egregious in the sense that he was his communications were being monitored without any knowledge on his part, or afterwards. He was not informed afterwards that he was being spied on. And that's quite a serious intrusion into somebody's very personal realm, their private communications. Here, this is a matter of the public interest. And in the broader scheme, we know that political party donations is something that is in the public interest, and that's why we have the Political Party Funding Act. And obviously the other case that from which this case arose, which was argued in the Constitutional Court, concerns internal political party campaign financing. And Amabhungane was admitted as a respondent in that case, and our argument there is that those disclosures should be made as a matter of public interest, and we argue that the executive members' ethics code provides for that. But we're not that disclosure is not the subject of this particular case. The EFF is making a specific argument in relation to a particular set of documents, and that's where we do not weigh in. We abide the decision of the court on that regard, but we do wish to put forward our submissions on open justice.
What about those, Cherese, who are the people or organizations that made donations to this campaign? What are you saying about their rights that their information, private information, whether it be banking details, that those be not revealed? Do they not have the same legal standpoint as that of the president?
We are saying that that's not a determination for us to make. So we're not getting into the fray on that point.
Yeah.
We're saying that those considerations must be put on the scales on one side, and on the other side, we have to consider the benefits of openness. So it's not for us to decide that, it's for the court. But our concern is that the court must apply the correct legal and constitutional principles when making that determination.
All right, Cherese Thakur, she is representing the Amabhungane investigative journalists, and they are friends of the court. You've heard from her. They are not with either side, but what they're advocating for is openness.